you very much for joining this afternoon's webinar on contractual aspects. Contractual aspects could be so many different things, such as ending a contract to save money or obligations that you have to continue. I'm delighted to welcome Alvin from ACUMEN Business Law. He's a solicitor specialising in commercial contracts. So thank you for agreeing to hold this webinar with us this afternoon, Alvin.
Hi there, thank you, Anna. Yeah, not at all. Hi there, everyone. As Anna said, I'm a commercial solicitor at ACUMEN Business Law. And what we're going to talk about today, as Anna mentioned, is your commercial contracts in light of the COVID-19 crisis. So I've got a presentation. Anna, are you going to share that?
Yep, I'll share that now.
So the reason we're talking about this, specifically talking about terminating agreements, is because since March, this has been one of the most common things that I have been asked by clients. Essentially, a lot of companies now are trying to save money and trying to cut costs, and to do that, they are trying to end services that they need and exit contracts. So I had a lot of people ask me questions about it on both sides of the coin. So one where people are trying to exit contracts, and then the other side where people want to keep their customers tied into their contracts. So I'm going to go through a few of the legal aspects today in a very quick manner, and then we'll have a Q&A, and you can run scenarios past me that might be of interest or that you might want to talk through. So if we could just move to the first slide there. The first thing that we are going to talk about essentially is some basics around terminating contracts. So and if we could just move, to the second slide, termination of agreements.
Yeah.
So essentially, this is the kind of basic. This is when we're talking about your commercial agreement. The first port of call should be the contract itself. Now, most of you will have contracts with your suppliers or your customers, and it may be that that's a beautifully written agreement with all the terms clearly set out, or it may be that it's an exchange of emails, or it may have just been a conversation over the phone where you've agreed to provide a service for a price. But that will be a contract. Now, the easiest scenario is where you have express termination provisions contained in a document. So you've got an express clause which deals with termination. It tells you how you can terminate, when you can terminate. That's the easiest scenario. But the important thing there is to ensure that you follow those terms precisely. So it's great that you've got that in place, but you need to follow those terms to the letter. Now, I often see situations which involve no terms. So it's where a contract was formed maybe by an exchange of emails. And in that scenario, there are two broad categories. So you've got this contract formed over an exchange of correspondence. There's nothing to do with termination. And there are two broad categories. So first of all, there are certain scenarios where you may have a fixed term contract. So it's a contract for a year or for a fixed project. And if there's no termination provision in that contract, the position will be that you can't terminate unless there's been a serious breach of contract or one of the other common law methods, which we'll discuss a bit later. So for a fixed term contract, you're tied in for that period, whether it's a year, 2 years, whatever. And in the other category, the other kind of broadly speaking scenario is where you have an open-ended contract. So that's a contract that's rolling, maybe it's month on month, quarter on quarter, and it's accepted law that in those contracts where there's nothing mentioned about termination, you can imply a term of termination on reasonable notice. So reasonable notice will differ from case to case, but it means that you may be able to get out of the contract and argue that there's an implied term. Now, some of you may well be thinking, that's all well and good, but if I need to end a contract because of coronavirus, I need to do it ASAP. And that's true. Some of these things will involve a month's notice or 6 months notice or whatever. But this should always be your first port of call, so your first position that you're looking at. So that's contractual termination. And either way, whether you're trying to terminate or you want to prevent termination of another party, that should be where you go to first. But the law recognises that there are certain scenarios which fall outside of the contract. So that's where common law comes in. You said termination within the contract. So that's where you've got either a written clause or an implied clause. But as I said, common law recognises that sometimes you need to get out of the contract early. So there are a number of common law methods for exiting a contract. So a question I will commonly ask at the moment, and I've been asking it for the last couple of months when clients come to me, is there a repudiatory breach of contract? Now, a repudiatory breach of contract is a serious breach that goes to the root of the contract. It's essentially fundamental to the agreement. And if there is a breach, the injured party can actually bring that contract to an end. Now, a common thing that I've seen a lot during coronavirus times is failure to make payments, or missed monthly retainer fees, or just missed payments generally. And sometimes these will be repudiatory breach of contract, which allow termination of the agreement. Now, it's important to bear in mind that, as it says there, it can be a double-edged sword. And the reason for that is, on one hand, you can use a repudiatory breach of the other party to terminate a contract. But on the other hand, if you do so incorrectly, so if you try and argue that and you're not actually right in that argument, that in itself can be a repudiatory breach of contract. And it can place you in, it can make you liable to the other side. So there's a brief case study there. It's actually a case I dealt with years before coronavirus, but it's still relevant, where party A was the other side, tried to sue my client, party B, for tried to terminate the contract with my client early, and we sued for unlawful termination and won. And the basis for that is that you can only terminate if there's a contractual mechanism, or there actually is a repudiatory breach. And if you don't do that, if you do it incorrectly, you're in breach of contract, and it actually allows the other party to claim the value of that contract. So a common dispute I'm dealing with at the moment is where parties have tried to terminate agreements unlawfully, and my clients are now pursuing the full value of that contract, because particularly at the moment where business is scarce, that contract is a valuable one, and they can't necessarily let that go. So repudiatory breach of contract is a way out of a contract, but it's really important to get it right and to understand when it comes into play. So moving on, we have a legal concept which is becoming more and more commonplace to hear at the moment because of coronavirus, is frustration. So what frustration is, it's a legal doctrine which basically means that performance of the contract has been impacted by an event. Now, coronavirus naturally could be one of those events, but there are three heads of frustration that you have to fall under. So it's impossibility, radical difference, or illegality. So where performance of a contract is physically impossible. So for example, with coronavirus, there is the travel ban and there are real restrictions on where you can and can't go. Or for example, you can't have mass gatherings. So that's impossible to have if you have an events contract. That would be impossible. Radically different is where the bargain that you've entered into is completely different. So what we call the commercial adventure in law. Completely different. The purpose has completely disappeared. It's not what you bargained for. And illegality is obvious, again, with the travel ban. Certain contracts are illegal. You can't enter into certain countries, etc., etc. So where one of those three scenarios arises, a contract will be frustrated, which means it's automatically terminated. You don't have to do anything, it's automatic. And this is something that I've seen a lot of companies try to rely on to get out of their contracts during the coronavirus crisis. And I think what I hope comes across with those 3 bullet points there is that it's a high threshold. It's not an easy argument to set out. And actually, it won't always be relevant. Just because something has happened like coronavirus and it makes things a bit more difficult doesn't necessarily mean frustration applies, but it may apply in certain circumstances, and it's important to understand, particularly if you've got a contract which is draining your business of money and you want to try and come out of that, there may be an argument around frustration. So there are a couple of points to bear in mind here. Firstly, it's not that the event is just unforeseeable. So it can't be enough to say, well, I never thought coronavirus would happen, therefore this contract must be frustrated. It's more than that. It has to be impossible. And that's why there's a load of case law around difficulty and extra expense, and that's not enough for frustration. So you can't just say this is more expensive, less profitable, it's more onerous. That won't be enough. It has to be impossible or illegal or radically different. Allocation of risk is another really important point. So I mentioned earlier that your first port of call should be your contracts that you have with your customers or suppliers or whoever. And that's because if you have a contract and you've taken into account these kind of risks, it may be that you can't rely on frustration. So if you're trying to prevent someone from terminating a contract, a customer, and you've got a contract with them, it actually means that you essentially could wipe out a frustration argument against your contract. So there's a case on this around Brexit, where a company had premises in Canary Wharf in London. Brexit happened, as we all know. and the company, the tenant said, well, I need to get out of this 10-year lease, and the lease is frustrated because we need to be in the EU. Our business needs to be in the EU, based in the EU. And the lease had an assignment clause which allowed the tenant to leave the premises. So the court said, well, it can't possibly be frustrated because the lease foresaw that at some point, for whatever reason, you may not wish to be the tenant anymore, and you would then assign the lease. So the risk of them not wanting to be in that property, whether for Brexit or any other reason, was allocated in the document, in the agreement. So allocation of risk is important. And the last point there is just to bear in mind, a frustrating event has to be outside of the party's control. Now, obviously, coronavirus is outside of all of our control. However, there are cases where a party's actions after the event, before considering frustration properly, are deemed to be the frustrating event. So for example, with coronavirus hits, the steps you take, if those steps are actually what made the contract impossible, the frustrating event would not be one that could end the contract because it will actually be you that's committed it. So you need to be careful, and early advice is always important. If you're looking to exit a contract and you think it might be that you want to argue frustration because it's become impossible, before you take anything that changes the status quo, you should really take advice and consider whether there has been a frustrating event in the form of coronavirus. So moving on, we're moving on away from termination of agreements, but really more to suspension of a contract or suspension of your obligations under a contract. So I think probably 9 out of 10 businesses I've spoken to have never heard of the term force majeure before March 23rd. And suddenly everyone heard about them. Force majeure clauses, they are in a lot of contracts, and what they do is they basically say, if a force majeure event has occurred, you will not be liable for non-performance. Now, there's a couple of important points here. Firstly, the wording of your clause is crucial. If a clause is worded generally, so any action outside of our control, then that is likely to capture coronavirus because obviously that's an event that's outside of our control or foreseeability. However, some force majeure clauses are more specific and they list force majeure events, and where such a clause exists but doesn't list pandemic, for example, it may be that coronavirus doesn't fall within that clause. So it's really important to understand the wording. Secondly, the timing of the contract is also crucial. If you enter into a contract in August 2019 and it has a force majeure clause, it's entirely possible that you can argue coronavirus is covered. If, however, you are still entering into contracts today, and while we all know about coronavirus, and you put a force majeure clause in, it's possible that there's an argument there that actually it was completely foreseeable that the pandemic would rumble on for another 18 months, and therefore if you try and rely on it later, you will not be able to. So timing is crucial. You also need to be aware of any steps you need to take to mitigate. So a lot of clauses will say that you have to mitigate the impact of the force majeure event. And finally, understanding whether this can allow you to terminate. Now, most force majeure clauses will contain a provision that says if the force majeure event goes on for 4 weeks or 3 months or whatever, the contract can come to an end. So again, force majeure clauses, along with your termination provisions, should be something you look at first. Now, if you're trying to prevent a contract from coming to an end, they can be really useful to say, look, we've got this force majeure clause. We can suspend everything for a few weeks and see how it goes, or for a few months and see how it goes. So really, really important inclusion in an agreement. So that was obviously a very whistle-stop tour. You know, each of those slides could be a presentation in themselves. But just to give you some top tips. First of all, as I said earlier, the contract should always be the first port of call. So an early assessment of your contract, considering any clauses which are beneficial. And also that will then allow you to take a commercial view, which is the second point there. I think everything I've discussed up to now is a legal point. And that's really great to understand where the law sits and how it benefits you. But actually, you know, I think there is a prevailing view that we are all in this together. And if you can preserve a business contact by, for example, I don't know, accepting lower payments or, you know, paring back a service, after all this, it's going to be much better for the business to have that contact, you know, in place. So something I'm often telling clients also is, in certain circumstances, you do need to take a commercial view and maybe, you know, kind of allow some of these rights to be waived. And finally, just be clear on your common law rights. As I say, particularly with frustration and repudiatory breach, they're quite time sensitive. So you need to be clear on those rights and understand how they work really from an early point. So yeah, I mean, as I say, it is a very brief whistle-stop tour of termination of agreements. My contact details are there. Obviously, feel free to jot them down, or Anna can share them. But otherwise, I'm happy to, and I think the intention is to have a kind of open discussion with a Q&A in it.
Yeah.
You guys can run any scenarios past me that might be
Thank you very much, Alvin. I think just looking at something that I know that ACUMEN were running, I know that they run their annual convention. So for us as well, we hold lots of different events, and sometimes you have to sign an agreement with the hotel, paid everything else. So in situations like that, I know the hotels for a lot of our events earlier on have been really great. They've actually said, no, you can rebook in 6 months' time, 8 months. So where would you stand if an organisation insisted, no, I mean, I suppose you've lost the deposit then, haven't you, and things like that?
Sorry, that cut out that just before you said about lost the deposit. So if the organisation...
So if you've had to sign an agreement with holding an event at a venue, you would usually pay a deposit, sign that contract and everything. 99% of the time, hotels have been really, forthcoming, and they've been able to extend it to later on in the year. I suppose you would just then lose that deposit if the hotel doesn't want to relax those terms, given the current situation.
Yeah, I mean, essentially, yes, that is the case, generally speaking. And it will depend to an extent on what type of termination, or what method of termination you use, or whether it's force majeure or something like that. If it's a force majeure situation where you rely on that contract, then yes, you would lose the deposit, unfortunately. Frustration is slightly different because it's deemed to be automatically terminated, and there are certain circumstances where you can actually have sums of money paid back, and the court would have to determine that, or you seek to agree it. So, generally speaking, yes is the answer to your question. You lose the deposit, but there can be, frustration can be quite a powerful thing to give you the ability to get some money back in certain circumstances. So yeah. Any other questions?
Let's have a look. I think there's been, Paul's just put a note on here. Found Premier Inn refunded him on a non-cancelable room as they were closed. Also a client flying 55 of their people to Cannes Film Festival had a quick and full refund from BA, which is great because we've been hearing that a lot of airlines are not actually offering refunds, and that they've credit notes, and that's caused a lot of anxiety. Yeah,
I think there's a PR thing, isn't there, with companies like BA and Premier Inn, and a lot of these companies are giving refunds. But equally, I mean, I've had a holiday booked to Morocco, and that we're having to fight over refunds there. So I think, generally speaking, a deposit is just that. It's a deposit, and it's often non-refundable. There's often a clause that says that. So generally speaking, there's not always a legal right to it. But as I said, sometimes, BA, for example, taking a commercial view on it, they're much better off, with their public image of giving these refunds back rather than the backlash of, the negative PR. So
yeah. I think also because we've got a contract in place with an external company, and it's an open-ended contract. But what we found was I asked them to say we'll put things on hold, and I think sometimes it's having a conversation with the other party about how a contract could work during a period like this, and whether it can be on hold and then re-established again after things go back to some kind of normal. But I think just having a conversation, isn't it, with the other party to help going down the road.
I think so, and I think I've had some cases, one in particular that stands out, which demonstrates just that. It's a contract. It was a contract for ongoing services worth 7-figure sum, and it became disputed. But my client said to me, look, if they had come to us and said, because the other side were the paying party, and said, actually, we just need to get through this for a few months and we can come to a deal, we'd have sat down with them. But because of the way they went about trying to terminate the agreement with no right to do so, it became, actually, we now have to pursue this because it's a lot of money that we're losing, and they're not, it's not like they're preserving a relationship, because it's become so it's contentious. So I think that really is the case. I know it's you know, it's odd for a lawyer to say maybe have a conversation, maybe, but actually, I think sometimes an initial conversation is the way forward in this kind of scenario before you press the button on going legal. But it is good to know your rights in the first place, so then you know where your strengths and weaknesses are.
I think, Paul, you've just added on a couple of other bits.
Okay.
About hotels, the airline, sorry.
Do you want me to mention it?
Yes, please. Yeah.
Yeah.
Well, I'll just put on there. I think people are expecting refunds at the moment. I mean, I paid a deposit on something and they resisted trying to give me a credit note, but if they go bust, I'll just become an unsecured creditor, which I don't want to be.
No.
And also, I think I'm going to be much more reluctant to use them in the future anyway if they don't give me a refund, and I'm not going to recommend them. So I think reputational damage is a real risk if you're trying to insist on contractual terms at the moment.
I agree completely. I think that's why a lot of these companies are doing that. I think Andrew has also had a question. The only way to enforce these clauses, yes, I mean, the only way to enforce them in a way which is binding is to go to court. But actually what I find, you know, we deal with a lot of SMEs, and actually you're right, there's often times where a value of a contract, you know, it wouldn't make sense to go to court, but it still makes sense for you to understand those rights, because then you can assert them in correspondence. And actually, often if you can assert a case robustly enough, that's the springboard to actually settle the deal. And with those smaller amounts, it's always better to settle. But before you settle, to have that leverage, it's important to understand where your strengths lie. But yes, I mean, to answer your first question, yes, to get a determinative, binding decision, it would have to go to court.
I think one thing we're also seeing is that a lot of businesses obviously shut down, they're working from home. Now there's going to be a change, or potentially a change, in flexible working and remote working. So some businesses are rethinking, do they really need that office space that they had before? So the contract agreements that they have with landlords may change, or they may want to negotiate a smaller space because they may not need such larger space. I can see a lot of that coming through in the next few months.
Yeah, it's another really, really common thing. I've had a lot of questions about break clauses and, you know, can we exercise our break clause now and stuff like that. I think when this first happened, I was, you know, it's not a legal point, but it's a point that actually a lot of landlords would be willing potentially to negotiate maybe a rent holiday or something temporarily, because the market is such that they want to keep that tenant in there. Now, I think you're completely right that actually a lot of people are realising we don't need, and as I say, a lot of people ask me that question, when can we get out of our lease? And I think that will be a big thing. In the coming months, I think that will probably be a huge thing, actually. A lot of people will realise that.
Yeah. Do we have any more questions at all from anyone? I know that there's going to be some questions about staffing, which is not commercial contracts, that's more about contracts and everything. In terms of being furloughed, that are potentially going to be made redundant. So I know that that's for a separate discussion. That part of ACUMEN also deal with HR.
Of course, yeah, no, definitely. It's something we've got a strong employment department that deals with that kind of thing. And I think you're right. Again, there's going to be a lot of redundancy discussions being had in the coming months, unfortunately. So, but yeah, definitely it's something ACUMEN does assist with. Yeah, and it would be a good sort of other topic actually to do.
I mean, some of the statistics we've been finding through our we do a national tracker, impact tracker on COVID, and also survey work. So at the moment, currently, there's about 2-3% of the workforce that have been made redundant during COVID. This is the people surveyed. However, 70% are on furlough. So we're likely to see the number of redundancies going up. We're likely to see the amount of space reducing. So that national picture is going to be very, very different in terms of, the contracts that need to be renegotiated, renewed and reviewed, the staffing aspect as well.
Yeah, definitely. I think that's something even furloughing staff is something that you need to have a consultation and agree with them. So that whole kind of remit is something that's a big, is a big thing at the moment. And it's a concern how many people furloughed are actually in jobs that no longer really exist anymore. That's, I think that as you say, that's going to be seen coming on.
We've seen the force majeure clause coming through as well for a lot of our exporters. So export companies that we deal with that are importing, exporting, we've seen a lot of these clauses coming through from some of the Arab chambers and from some businesses as well. So it's interesting. It's coming more and more common now, but then it'll be interesting to see how that impacts contracts moving forward and whether it can be included, pandemics can be included, or COVID specifically.
Yeah, I mean, it's really interesting because force majeure clauses, when I studied law, was one of these kind of terms that you learn as a student and you think that you're never going to have to deal with in practice because they don't often come into play. But actually, you're right. And I think that now people are really alive to the importance of them, making sure that they're drafted properly to include pandemics and things like this. And I think they are, they are definitely something now that are more relied on, countless people having to point to them and say, well, actually, we can not pay you for 4 weeks because of COVID. So really, really important for us to have. I highly recommend, if there's one thing to take away from this, is actually having a carefully drafted agreement with the appropriate force majeure clauses is crucial, I think.
And should the force majeure be in just contracts, or should it be something that you look at as part of your insurance as well?
I think they're slightly different things. I would say that a force majeure clause should always be in your contract, but you should always be looking at any insured risks and making sure that you can cover them with insurance. But it's more of a contractual thing.
Okay. Has anyone got any further questions or any queries about any of their contracts at all that they'd like to ask Alvin? No? Was there any final words that you wanted to add to this, Alvin, or any updates at all about ACUMEN and what we've been seeing in the last few weeks?
Sure, I think in terms of the topic itself, as I say, big takeaway, making sure you've got those contracts in place. If you don't already have them going forward, at least they'll protect you as this situation rumbles on. And I think that is one of the big takeaways, that and the kind of commercial approach to it all. And just generally in terms of ACUMEN and COVID-19, I don't know, many of you may have seen that we're actively trying to support communities. We are all in this together. So, we have our Corona support scheme that has been very popular, and we are assisting clients and with all kinds of HR redundancy discussions as well. So, please do feel free to get in touch. We always, at the moment with the coronavirus crisis, we're having initial conversations at no charge for half an hour, 45 minutes to understand anything that you want to look at, and then we can carry out some work under that coronavirus scheme to assist. So do feel free to get in touch, really.
Brilliant. And details for ACUMEN are on our website as well. That's brilliant. Thank you very much, everyone. Thank you for joining us this afternoon, and hopefully you've all been able to pick up some tips and in terms of your contracts. But hopefully you'll see us again in next week or two, and we'll be putting on some more webinars. Thank you very much.
Cheers, guys. Thank you.